All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1049. Vanda Pharmaceuticals, Inc. Petitioner versus United States Food and Drug Administration et al. Mr. Hughes for the petitioner, Mr. Yelling for the respondents.
Good morning, Mr. Hughes.
Good morning, Your Honor, and may it please the court, Paul Hughes for Vanda Pharmaceuticals. I'd like to start with why we're here. FDA has sought to arrogate to itself control over drug development. FDA has decided that it itself will determine which new drug indications are appropriate, and FDA has escalated the standard of evidence for drug approval far beyond what Congress intended, in part by refusing to consider objectively evaluate the scientific evidence that applicants submit. Now, Vanda is a pharmaceutical innovator, and it has suffered immensely. It has spent tens of millions of dollars to develop a novel treatment for jet lag. The evidence, in our view, is overwhelming that Hetlioz works to treat this condition. People fall asleep far faster and stay asleep far longer than FDA requires for all other sleep medications.
But that's just a sleep disorder, isn't it? There's a difference between a sleep disorder and jet lag disorder, isn't there?
Well, yes, Your Honor. There are 18 approved medications for a variety of sleep disorders. Jet lag is one kind of sleep disorder. And our evidence is that this works essentially better than any product that's been approved for all the other forms of sleep disorders. But ultimately, we think this case doesn't require the court to make a determination as to this drug is necessarily approvable. We think where FDA absolutely went wrong was denying Vanda a hearing. The evidence to us is quite clear that there are a multitude of disputes of facts. So everything that's in part 2 of our brief, both our opening brief and our reply brief, illustrate the broad variety of true disputes that exist in this case. And because of those disputes, our principal submission to the court was that essentially the grant of summary judgment, the denial of a hearing, was improper. So we don't think the court needs to wade into the various disputes, because those actually deserve a hearing where there will be a testimony by our experts, testimony by FDA's experts, and there can be a contested proceeding in order for FDA to fairly evaluate all of that evidence in the process that Congress created.
Well, doesn't that just boil down to your subjective sleep measures, which were not pre-specified? That's kind of like, once I kind of dug down through it all, it seemed that that's kind of the main issue there.
So, Your Honor, FDA's principal contention is that because their submission is that we don't have evidence of efficacy as to next day functioning, what they call a criterion B, that they can grant summary judgment. There are 3 independent problems with that. First is the sleep experts show that you don't actually have to treat criterion B symptoms in order to get approval. The 18 drugs that I mentioned, as Dr. Roth explained, none of them, except for one only for half of its indication, actually has a criterion B indication. And Dr. Roth explains why you don't need criterion B indications.
So if we could just dig down on that for a minute, because my understanding of your argument is that the FDA says we treat essential features. We don't look at the criterion. We're looking at essential features. For jet lag disorder, the essential features happens to include a criterion B criterion, if I can finish, which is impairing next day function. You're saying there are all these other drugs or other disorders that have essential features that include criterion B, and drug companies haven't been required to address the criterion B symptoms. But when I actually look what's in the record of the disorders of insomnia that you point to, they don't include criterion B features. So chronic insomnia disorder has a single essential feature. It's frequent and persistent difficulty initiating or maintaining sleep that results in general sleep dissatisfaction. That's the essential feature. There's no criterion B in that. It goes on to say the sleep complaint is accompanied by distress, poor sleep. Those are criterion B things, but that's not an essential feature. That's just something that accompanies the essential feature. So if I can finish, likewise, short-term insomnia disorder, same thing. there's a singular essential feature and it's accompanied by criterion B features. So I don't think this record supports your argument that the FDA is being inconsistent when it talks about essential features. Because the essential features can include A, it can include B, it can include D. For jet lag disorder, it happens to include B. And there are plenty of other ones where they don't include B. I just don't think this record supports your argument.
So let me address this in a multitude of ways. So first, I have two independent arguments, even if the court rejects me on that, that show why we've actually proven next day functioning. So even if we have to, we have a dispute of fact as to whether we've proven next day functioning. We also have a dispute as to whether or not a narrowing of the indication would solve that. That's my point one. I want to come around to that. So I'll get to the court's question. The point two, before I get directly to the court's question, is our principal contention is that what actually qualifies as jet lag disorder is a scientific issue. It's not an FDA regulatory issue. This is decided by sleep medicine experts, some of which may reside at FDA, but not all of which.
Isn't the ICSD
Yeah,
compiled by sleep experts? Are
let's
you disputing that the ICSD is an appropriate source?
Yeah, and let's talk about the ICSD. So if the court looks to Joint Appendix page 2088, this is the ICSD listing. And so this is the description of chronic insomnia disorder. And as the court noted, diagnostic criteria B includes, for example, fatigue and malaise. And there are 9 of them, and that's at Joint Appendix page 2085 to 2086. Then at page 2087 is where the ICSD begins discussing its description of essential features. And if we turn the page to 2088, this is all in the description of essential features. It describes everything that is contained under criterion B.
No, I don't think so. I mean, I think just because there's a section of the document that says essential features, you have to read the document. The document more specifically says, as I said, for chronic insomnia disorder, the essential feature, one feature is, and it's one sentence.
But there's a whole description. This is under the heading. So at 2087, there's the heading essential features. And then at 2008.
No, I understand the heading says essential features, but you have to read that section. And within it, there's a sentence that identifies what the real essential feature is.
But then if you turn to page 2089, it describes associated features. What we think, and this is what Dr. Roth, I believe, describes, is that what is contained under the heading essential features are the essential features of the disorder. It's not just one single sentence. I
don't think we cannot read that particular provision. The sentences say, which don't support your.
The heading says essential features, and it has multiple paragraphs that describe essential features, and has a second description of what associated features.
You have to read the section. Just because the heading says essential features doesn't mean everything that's in that is an essential feature.
And I think this is an interesting dispute, which is exactly the kind of thing that goes to a hearing, because you can have sleep experts.
I think not, because I think it shows that you haven't met your burden to establish that there's any problem with the way the FDA handled this.
But again, as I said, this argument is sort of one of multiple independent arguments that we present. So even if I can't convince the court that everything that's under essential features is actually essential features, as distinct from associated features, which is separately spelled out by the ICSD, which is how Dr. Roth, our sleep expert, says one trained in sleep medicine would understand this, which shows that there's a distinction between insomnia. I think that's pretty powerful, and I think that on its face deserves a hearing. But even if the court disagrees with that submission, I appreciate not to convince Your Honor, we have lots of evidence that even show we do show next day functioning. This is with the KSS and the VAS scales. Sure. So on the KSS and the VAS and the other associated evidence of next day functioning, we think there is a tremendous wealth of evidence that exists in the record demonstrating how individuals report that they have substantially improved next day functioning as a result of taking this drug. I think what FDA's...
What about the pre-specification?
Yeah, so Your Honor, there are two problems with the FDA's pre-specification analysis. The most important that I'll point the court to that FDA has essentially no response to is we provided an expert declaration from Dr. Platt, which did an analysis showing in this context, what you're trying to control for with pre-specification is what's called type 1 error. That's the result of a potential false positive. So as FDA's analysis points out, they're not wrong in an abstract matter that you do pre-specification so as to avoid doing a post hoc analysis and finding data that points to a conclusion but has a false positive risk associated with it. That's the general theory. So I don't disagree in the general abstract. That is, one thing that one considers. What Dr. Platt did, though, is and said, let's look at the actual risk of type 1 error in the facts of this case using all the evidence before us. This is at page 2,299 of the record where Dr. Platt has his conclusions. And he says there are 22 separate endpoints that have been shown in this throughout all of the studies. He did a meta-analysis, and he said all 22 endpoints show directional improvement. And so in that context, where everything shows that this product works, the risk of there being type 1 error is negligible. And he said there's no material risk.
Isn't one of the things that the FDA said about Platt's declaration was that essentially what you did was take your answer to each individual study suffers the same flaw was to do a meta-analysis of all the studies with the same flaw, and that can't fix the flaw. It's just now intrinsic and embedded into your meta-analysis.
That's what they said, and frankly, that's an absurd position because the whole point of Dr. Platt, who's an expert in statistics, is to say, I know what you're trying to control for as a general matter is type 1 error and the reasons that you have pre-specification. But I can look in the context of this particular case, use scientific methods, and explain why what it is you're trying to control for in type 1 error does not exist in the context of the evidence that we have before us. So sure, if you look at an abstract theoretic matter, is that pre-specification have some value? Yes, but the question is, what does it do in the context of this evidence before us? And Dr. Platt says essentially nothing. And FDA has no response to that other than to say, well, it is also post hoc. But the absurdity point of that is he's describing from an expert perspective why the post hoc feature of this is not actually a problem. And FDA doesn't respond to that with any substantive analysis. They just essentially say no.
Give you a hypothetical. Like, I'm not an expert in, I guess, statistics or, what's the best way to do a study. But it seems to me that what is at stake here, what's in play, is just a sort of a methodological accepted practice, which you should pre-specify to avoid a certain type of error. So if we had, for example, a sample, usually I think you need to have 30 or more for a sample, and Vanda came up, well, we have a sample of 5, and the criticism was, well, that's not a big enough sample. And Vanda got an expert that said, well, usually you need a sample of 30, but in this case, it was just so convincing that you should accept our sample of 5. Would the FDA not be able to be like, we don't accept your methodology because on its face, that's not?
So what American Sinamid, this court's case, I think addresses that, which says if you have a dispute of fact that is quote unquote palpably shallow, then a palpably shallow dispute of fact is not something that entitles one to a hearing. We don't think these disputes of fact are remotely to the range of being palpably shallow. And though to get to the particulars of this.
But what about my hypothetical? Because that seems to be similar to what you're saying here. There's a methodology that's accepted. We didn't follow it, but we have an expert that says it doesn't matter. And what about my sampling hypothetical?
Well, I think
FDA, would you have to have a hearing on that if you only had a sample of 5?
I think the question is there a finding that analysis is essentially palpably shallow and there's no meaningful dispute around it? And if one can draw that conclusion at the summary judgment standard, it's not distinct, I don't think, from how the court looks at summary judgment saying there's no actual essential factual dispute here, then a hearing would not be required. But in circumstances where there is a dispute, and here we have a pretty expert statistician who's explaining why there isn't a risk of type 1 error in this context, and we're not here, FDA has no actual technical or meaningful argument. They just have an attorney argument saying it has, it's post hoc, but the whole point of the analysis is to explain why not all post hoc analysis is bad. And this kind of goes to the broader problem here is FDA can always say, run another test with another kind of pre-specification. You can always do more and more to try to eliminate what's called type 1 error. But the problem that you have is you lead to a graveyard of unapproved drugs because you lead to type 2 error, which is you have false negatives. If you make the standard too demanding, you have products that actually work, which is this product, that don't get to approval. So there has to be a balance between trying to control for type 1 and type 2 error. And again, I'm not saying this court strikes that balance. I'm saying you have a hearing to strike that balance.
Can I just go back to one of your other arguments is that your evidence does show the type of improvement in next day functioning that FDA was asking for.
Yes.
And am I right that the main evidence you're referring to is the KSS and the VAS metrics?
Yeah, there are other pieces of evidence, but those are the two
But
principal.
aside the questionnaires and all that, but
Those are the two principal, yes, Your
right.
Honor.
And so my understanding of what FDA said is you may have evidence that those are measures of sleepiness versus alertness. And you might have, it might be true that if you say you're sleepy, that will correlate with next day functioning. But those don't capture the situation where somebody feels alert, but is still impaired in their functioning on the next day, which FDA says their definition is that that's the key sort of independent feature of jet lag disorder. You could separate from sleep disturbance because of the circadian rhythm change, you're going to have next day functioning problems. Do you have evidence that goes to that kind of?
Well, that's what Dr. Roth tells us, is that KSS in the sleep medicine world is sort of the gold standard for figuring out how somebody is performing on the next day, is looking at the KSS standard. It is, do you feel—
In the sleep medicine world, not in a circadian rhythm, you've traveled to the other side of the world. And I don't fully understand this, but the FDA says, and the ICSD says, separate, even if you're sleeping totally fine, the fact that your circadian clock is so off is going to impair your functioning. That's an essential feature of jet lag. And I don't think Roth speaks to that.
No. What Roth says is the way that you get at that question about next day functioning is you do these surveys of people and you ask them, how are you functioning? What is your alertness versus your sleepiness level? Because that is what is directly tied to your functioning in a particular day, is how somebody's doing compared against their baseline. So it's not— the evidence that goes to criterion A is you fall asleep faster and you sleep longer. Those are objective scientific facts. The next question about if we get to criterion B, if that's even required, and again, we have a disagreement about that, but if it's required, then the question is, well, what's a way that you show your next day functioning? You learn from people what their objective, or how they experience their performance, what their alertness versus sleepiness is that next day. And I think—
So you're equating performance to alertness versus sleepiness. And here's just one way of many that FDA made this point. I just want to know what your response is. So they say, quote, "The scale would not capture the impairment of someone who felt subjectively alert, but performed poorly behind the wheel of a car."
So this kind of goes to the key problem, is FDA can always come up with some other test of, oh, put somebody behind a wheel of a car, but nothing in criterion B says put somebody behind the wheel of a car.
It's just an example, right? The fundamental point is you could have somebody who does not feel sleepy, feels very alert, but is functionally impaired, and that you didn't measure do any study that goes to that. At least that's my understanding.
That's wrong, Your Honor, because the alertness study is the person functioning. That is directly tied. That's what the evidence shows, is if the person is alert, they have that degree of functioning. But again, these are not questions that I think this court needs to be deciding. These are questions that are scientific expert questions about people who actually spend their life doing sleep medicine. And now maybe FDA disagrees with Dr. Roth's explanation of what KSS and VAS show and how they demonstrate next day functioning. And that's a fine dispute for us to have on a full factual record where FDA produces what it is that they believe is the evidence that contradicts our evidence. But right now, we don't have any evidence from the FDA. We just have FDA rejecting our evidence. And again, the statutory standard, to bring it back to, is substantial evidence. As FDA has said, this is often a low standard. We don't have to have overwhelming evidence of efficacy. We don't have to have every conceivable piece of evidence that FDA might wish we have. The question is, do we have substantial evidence of efficacy? And again, going back to the statutory standard, what's critical is there a qualified expert who fairly and responsibly concludes that we have demonstrated the effectiveness of our drug? We've provided two experts.
It seems to me that the implication of your argument is that anytime a drug company has an expert that says there's a question of fact here, the FDA has to hold a hearing. Because the standard says, you have to have substantial evidence, but the practice is if there's no way you can meet that standard, the FDA shouldn't have to waste its time holding a hearing. But what you're saying is anytime a drug company can get an expert to come in and say, actually, our opinion is there is a question of fact here, the FDA has to hold a hearing?
So I have a few responses to that. First, there is a relief valve on the palpably shallow as American Cyanamid this court held. So it is not in every case. But second, as a factual matter, we describe in our brief, there have been only 5 since 2018, and I think this stretches back at least a decade. There have only been 5 requests for a hearing in all of FDA, and FDA has denied a hearing in all 5 cases. So we're not in a situation where FDA has a glut of hearing requests or a glut of hearings. They deny all of them.
You
Now,
say that they never have hearings?
so far as I know, no.
So drugs get approved.
Without, the approval happens without a hearing, right? That the approval happens with a lower level official issuing an approval letter without a hearing. So there are no hearings on drug approvals, essentially. There are advisory committee proceedings. That's the closest the FDA comes. But in my knowledge, and we go back at least to 2018, there's not been any hearings before the commissioners on drug approval.
So my impression is, and correct me if I'm wrong, it seems like it's a sort of interactive, almost collaborative process, because just from reading this record, it seemed like there was a lot of communication between Vanda and the FDA. We want to do this. FDA says, well, our concerns are this. Can you address this? You go back and have studies. You try to address the concerns. You come back. So is that why, and that there usually aren't hearings? Because usually it's more of a collaborative and less of an adversarial
Well,
process.
I mean, I'm not sure if we cited in this brief or in else, but you know, a former general counsel of GSK was quoted as saying, when FDA says jump, if you're in the pharmaceutical industry, you ask how high. That is how usually drug approval works. So I will agree with that general approach. But the point is, Congress put into the statute a hearing mechanism for when there are actual disputes between the agency and the parties, the applicants. And you know, I think American Cyanamid which is sort of shocking to me, a case that the government doesn't even cite in their brief. It's a feature of our opening brief from this court. The government doesn't even cite it. If you look at the concluding paragraph of what this court held in American Cyanamid, it is this case. And so here's what this court said. Cyanamid presented FDA with scientific studies, which in the opinion of some experts proved that Proban may be safely used by dog owners without professional supervision. This was about an animal product. So that's our case. We have scientific studies, the opinion of experts. Cyanamid's experts disputed FDA's interpretation and critiques of the study's results and methods. So we dispute FDA's interpretation and critiques of our studies. That's exactly what our experts do. They raised, too, a number of material questions about the appropriateness of the methodological standards the director attempted to graft onto the statute. That's exactly what we're doing. We're saying he's putting, or the FDA is putting additional standards onto the statute. Then last sentence, in short, the papers on file in this matter generate several material issues of fact and science that FDA attempted to resolve without a hearing in contravention of the Food, Drug, and Cosmetic Act. That is our case.
Just in terms of what the standard is, do you think is it essentially the same standard we apply in summary judgment cases? Is there a material dispute of fact, or is there some other more demanding feature?
I think as a practical matter, it's probably similar, Your Honor, to summary judgment standard. What the American Cyanamid case said is if a dispute, and I've said this a few times, is palpably shallow, then there would be no need for a hearing in those circumstances. So it can't be a trivial dispute of fact, or it can't be something that a court could say.
The mere material dispute
That's right, Your Honor.
is certainly a material dispute.
So, Your Honor, I think palpably shallow material dispute is probably synonymous, but yes, so there is, in back to Your Honor's question, we're not suggesting that every dispute automatically gets there. There has to be a material dispute, and we think our expert.
Doubting is the government. I didn't see it anywhere. I just want to confirm. They're not doubting that your experts are indeed experts in the field. Is that right?
No,
that's not the least bit contested. So,
yes, Your Honor.
So there's a joust between so-called experts on the government side and so-called experts on your side.
And, Your Honor, frankly,
material disagreement to the matter and issue, right?
yes, Your Honor. We don't know who the government's experts are. At a hearing, we'd like to cross-examine them, and the government can cross-examine our experts. We can test those disputes, and we get a better process, a fair process, when those experts get subject to a hearing, and then FDA adjudicates what it views the correct result to be. Again, what we ask the court for is simply an application of American Cyanamid. Again, when I was preparing and read this court's concluding paragraph, it feels to me like that paragraph could be written for this case because we are in exactly the same circumstance. I don't deny these are important disputes of facts, and we are not asking the court. Let me say, the court does not need to resolve any of these. It just needs to recognize that these are pretty weighty disputes that warrant scientific treatment.
Thank you. We'll give you 2 minutes for rebuttal.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court. I'm Louis Yellen from the Department of Justice. I'm here today on behalf of the FDA. I'd like to start with Judge Pan's observation about the collaborative nature of new drug and supplemental new drug applications and describe how the process usually works and what happened in this case.
Let me go to the point that they're raising, which is what's before us. The statute says very clearly they're entitled to a hearing. It doesn't say maybe. It says they're entitled to a hearing. American cyanamide is the law of the circuit. It is controlling precedent. And as I read it, and as I read other cases like it, it seems very clear to me that disputes among experts on a scientific question involving expert scientific judgment are material factual disputes. I cannot comprehend in reading your brief and in reading the other side's arguments how you can possibly say they're not entitled to a hearing. I don't know who'll win, but experts, and you don't contest that they're experts, experts disagree with the scientific judgments that have been offered by the agency. These are factual disputes. They are in lots of contexts of the law. And I really was kind of amazed at your argument. It's kind of like we exist. And if we look at the record and we think we're going to end up ruling against you, we don't have to have a hearing. That's not the law. That is absolutely not the law. And American cyanamide is the law of the circuit.
Respectfully, Your Honor. So the law of the circuit is also PMRS and Campanos. And Campanos, and I'll respond specifically to American cyanamide, but to set that up, Campanos says if the FDA has given adequate notice of the necessary evidence, it can determine without a hearing that there is not evidence in the record that could support
Their
an approval.
experts disagree with you about whether or not.
If I might finish,
No,
Your
well,
Honor.
let me put
Yes,
it in
Your Honor.
context. Their experts disagree with you about whether or not what's being proffered by them is adequate to support the conclusion they reach. You can't just say, well, no, we're not going to accept it.
Your
You
Honor.
don't have any regulation that forecloses them from offering the evidence that they're relying on. And it's certainly not implausible. I don't know who's right, but there's certainly nothing implausible about it.
Your Honor, as Judge Pan observed a little bit earlier, just because an expert says something doesn't mean that there's a genuine and substantial disagreement of fact. An expert can make conclusory statements that are not supported either by reasoning or by studies.
I read these expert statements. They're not conclusory. They're going through what's before you, and they're saying, here's the way we analyze it. And that's a dispute between experts. This goes on all the time. In the forensic science world, goes on all the time.
Respectfully, Your Honor.
Competing experts disagree on how you assess the record and what's a viable conclusion in light of your assessments. That's a factual dispute.
Respectfully, Your Honor.
Is that a factual dispute?
No, Your Honor.
It's not a factual dispute
No.
because the agency says no?
If I might respond, Your Honor. The dispute here is about standards, not about facts. For example, the dispute about whether the so-called subjective endpoints, the KSS and so forth, produce statistically supportable studies is about whether or not you can have a study that does not pre-specify its analytic methods and whether that can support robust findings from the study.
And they've answered your contentions on that. They've answered it in a way that is entitled to be listened to, respected, and then heard, and then you make findings after you listen to both sides.
Your Honor.
I must say, I didn't want to have to go through this, but I did go through it, and what they've said is not stupid or implausible. These are really smart people in the field in which you're claiming to have expertise as well, and they completely disagree with you on how you assess what's before us. The statute seems absolutely clear. They're entitled to a hearing. You may
Respectfully,
win, but they're entitled to a hearing.
respectfully, Your Honor, if an expert says 1 + 1 = 3, you're not entitled to a hearing. And the argument about
Because
statistical,
1 + 1 = 3 is discernibly wrong.
and Your Honor,
What you're saying is not discernibly right. You're saying we don't assess sleep disorder in that way. Another expert says, no, you can assess sleep disorder in this way as distinguished from your way. You are not discernibly right. I don't know whether they're right. There's a dispute between experts, and what we do in the law and in the forensic science fields goes on all the time. In the challenges under Daubert, this is what happens. Experts come together. They disagree on how you assess the approaches, the methodology, the results, and what they mean. That's why you have hearings.
but Your
You
Honor,
don't have the judge say, in those kinds of cases, I'm just deciding it. I don't care what the experts say.
Your Honor, that's not entirely correct. Even in the Daubert,
Entirely correct?
even in the Daubert setting, there are circumstances where you don't get to a hearing because the experts have
Yeah,
not.
the 1 + 1 = 3.
Right, Your Honor. And pre-specification is a basic method of statistical analysis. It is so basic, it is so fundamental that the FDA has guidance going back decades about the need for pre-specification in statistical research. The
Why are you afraid of a hearing to make that point? You're afraid they might come up with something?
I'm sorry,
that
Your Honor.
will disprove your point? I don't get it. The statute's so clear on their right to a hearing.
Your Honor, and this court in Campanos, in PMRS, in multiple opinions has recognized that unless there is a substantial and genuine issue of fact, a hearing is not required. If so long as the FDA puts on notice the applicant of the sort of evidence that needs to be submitted, if that evidence is not submitted, and here there was not valid evidence submitted about treatment of impairment of next day functioning, no hearing is
Can we
required.
just go another level down on the pre-specification issue?
Yes, Your Honor.
So my understanding is the problem with not pre-specifying is that there's a risk of false positives.
Yes, Your Honor, that's
They
exactly right.
enlisted an expert, a statistical expert, to specifically address that issue. And he concluded, based on some kind of analysis contained in an expert declaration, that here there was no risk or a very negligible risk of false positives. So, and the response seems to be, but you have to pre-specify to avoid false positives. But the actual specific response to his declaration in the CDER reply gets very technical. Doesn't seem to say you didn't pre-specify. Regardless, if they've shown, they have someone saying there's no risk of false positives here, why doesn't that create a fact dispute over facts
So
and
the-
matters?
I'm sorry. Your Honor.
Yeah.
The FDA order incorporates the CDER explanation
Correct.
rebuttal. And one of the things was the failure to pre-specify. Perhaps we used too shorthand an explanation, but the idea was the following. If you do a meta-analysis of a bunch.
Is this in the record?
Yes, Your Honor.
I thought you said you used the shorthand and didn't explain this.
I was talking about our brief, which I believe Judge Garcia was referring to.
All right.
So, Your Honor, at 239 to 41 is FDA's discussion of the meta-analysis and the express adoption of the center's analysis, which is at 2449 to 53. The problem is, if you do a meta-analysis of a bunch of studies that have inherent flaws within them, those inherent flaws, as Judge Pan, I believe, observed in the colloquy with Mr. Hughes, those inherent flaws are going to carry over to the meta-analysis. FDA has explained that meta-analyses are useful when you have studies that pre-specify and themselves are analytically sound. Doing a meta-analysis that just carries over inherent statistical flaws is not going to be an answer to the inherent problem of the lack of statistical rigor in the underlying analyses.
I guess the point is, the standard is not just, does that seem reasonable to us? It seems the standard is there a dispute of fact? And their entire expert declaration, it's essentially saying that what Platt did was totally useless because you just can't overcome the risk of false positives by doing this kind of meta-analysis. And his view obviously is you can, that's why he did it.
Right.
And you're disagreeing with it.
So
It's hard for
that's,
us to say there's not a dispute, isn't it?
there's a dispute. It's not a dispute of fact. It's a dispute about statistical methodology. And in Simpson, this court said, and I'm quoting, explication of the proper method for evaluating statistical significance, and that's the end of the quote, is something to which this court defers to the FDA. The sort of methodologies that are used is not the sort of question of fact that some summary judgment proceedings, that hearings are meant to suss out. Conceivably,
You can't be serious in that assertion.
if I might finish my,
No. I want to stop you in the middle of that assertion.
I was going to explain that assertion.
The
further.
argument is between equally strong scientific people, say, arguing over the methodology. And you're saying if there's a dispute over whether A and B are viable, that is not something that raises the kind of factual dispute?
Yes, Your Honor. It might raise a potential argument about arbitrary and capriciousness.
No. I'm putting it right to the summary judgment kind of.
I know you are, Your Honor. I'm trying to give you my response, the FDA's response, which is if an applicant believes that the FDA has inappropriately adopted a statistical methodology, they can bring an arbitrary and capricious claim about the agency's adoption of that methodology.
If the FDA has a methodology that says 1 + 1 = 3, the only claim I can make in challenging that is that it's arbitrary and capricious. It may be arbitrary and capricious, but in part because it's factually wrong.
Your Honor, the analogy in this context is not the statement 1 + 1 = 3. It's what does the plus sign do? It's an argument about.
You must use the methodology whereby 1 + 1 = 3. That's the way we think about it.
No, Your Honor.
I'm just giving you my example. If you use
Okay.
our methodology, 1 + 1 = 3. I can't challenge that as a factual matter?
No, Your Honor, it's not a factual challenge. It's an arbitrary and capricious challenge. And in fact, in American cyanamide, the court held that the agency had acted arbitrarily and capriciously. It didn't say that the agency made an error of fact. The problem in that case was that the agency adopted a methodology without giving fair notice to the applicant. So I think Mr. Hughes' principal case supports the idea that arguments about methodologies are properly conceived of as challenges to whether or not the agency acted arbitrarily or capriciously. They're not challenges about facts which are to be resolved in hearings.
Well, I think most of us agree that your burden is high here. You have to show there's not even a dispute of material fact. So we've talked a lot about this type 1 error issue. But the other ground on which it seems to me you could win is if there was just no dispute of fact that the sleepiness metrics, the sleep versus alertness metrics, speak to the type of next day functioning that is an aspect of jet lag disorder. And I had some questions for Mr. Hughes about that, but I guess I would just like to hear your best argument on that issue.
Yes, Your Honor. Your line of questioning did mirror implicitly the FDA's understanding here, which is Vanda failed to establish that metrics concerning degrees of awakeness actually correlate to degrees of functioning or treatments for impaired functioning. So the example Your Honor gave is a good one. Individuals who report the same level of awakeness using the KSS scale might not perform very well in a driving test, for example. And that's not the sort of inquiry that Vanda undertook. It just took the scales, the degree of alertness scale, to be a stand-in for the impaired functioning without any underlying analysis. They have experts who say the KSS standard is the gold metric. Well, they do not have any studies or any underlying literature to show that the standards that they used are themselves indicative of the impaired functioning that is associated with jet lag disorder.
So they do have, so the Combs Declaration, for example, has a whole section saying that this measure of sleepiness is a way of assessing next day impairment. And well, I'd like to see how you'd put the response.
Yes, Your Honor. The FDA specifically responded to that by saying those are assertions. The citations that were made do not refer to any literature, any studies, or anything that shows that correlation. The expert gave his opinion that there was a correlation here, but without any supporting evidence. And that is an example of the sort of conclusory evidence that was submitted along with Vanda's application.
See, that's precisely the kind of thing, it seems to me, you do in a hearing. They bring in, you say what you say, they bring in what my colleague has mentioned. And then if you think there's something that undercuts it, you have an opportunity on cross-examination or in presentation of your own case to show why what they're asserting is limited or of no use. I mean, I must say in reading what they offer, it certainly doesn't come across to me as implausible and unsupported.
I
And
understand.
that's what a hearing is for.
If I might, I'd like to briefly return to where I was starting, which is to say the application process usually is an iterative process between the applicant and the agency. Disputes like the one that we have here are extraordinarily rare because the agency and the applicants agree on what has to be established. In this case, Vanda identified the ICSD standard as the standard for defining jet lag disorder. FDA accepted that understanding of jet lag disorder. And I should pause to say essential features of that disorder are critical here because the FDA agreed with Vanda that that standard accurately captured what jet lag disorder is. But whether something is an essential feature really comes out through this iterative process, what has to be established to gain approval of a drug. Despite the fact that Vanda itself identified the ICSD standard as the prevailing standard, Vanda supplied no valid evidence that there was actually an effect of its drug on next day functioning. Its principal studies concerned how well the drug allowed somebody to sleep. The studies that addressed degrees of awakeness suffered from the two different problems that we've been discussing, the statistic methodology flaw and the failure to correlate the degree of awakeness and other standards that they used with functioning. So on the standard that Vanda itself submitted to the FDA as defining what jet lag disorder is, Vanda's evidence was insufficient.
That's the whole, evidence is insufficient. That's what a hearing determines.
Categorically, Your Honor, they identified a standard that says you have to have X, Y, and Z. They supplied evidence of X, they did not supply evidence of Y. So on their own terms, they failed to provide evidence that they acknowledged was necessary. And to be, just for the court's reference, JA 2013 is a citation that shows that it's Vanda that supplied this definition that the FDA later accepted as the governing standard for this application.
So if I could sort of try to frame this in a way that's easier for me to understand, it seems like there are two levels of dispute here. There's the level of the actual finding that needs to be made through a hearing, which is whether or not there's evidence this drug does what it purports to do. And those are the types of things like factual disputes that are suitable for a hearing. But before we even get to that level, there's another level of dispute, which is what kind of evidence can prove that. And it seems that there is no dispute as to what the evidence of the methodology was. We're talking about the methodology dispute, not the actual factual disputes about the drug. The methodology was, we have KSS, we have these other ones, they're subjective, we did not pre-specify, everybody agrees. And the dispute on that level is whether that evidence is strong enough even to get you to a hearing, because it seems to me it's the FDA's view that if you don't pre-specify, that data is not strong enough, I guess, what Mr. Hughes would say, shallow level dispute. It's a very shallow level dispute because everybody knows through many decades of understanding of statistics and methodology that you have to pre-specify, because if you don't, your data is no good. So we don't need to have a hearing about whether pre-specification is necessary or not. That's not the type of factual dispute the hearing is for. The factual disputes for the hearing are, does the drug work or not? But there's a threshold question about what evidence can be used to get you to a hearing. And if you could explain, like, what is if the FDA is relying on just decades of experience, you're saying that the FDA gets some deference in terms of that kind of threshold level. And I want to understand better, like, where does that difference come from? And what is the FDA relying on this case to say, this is a dispute that's not even worth having at a hearing?
Yes, Your Honor. So in Simpson, the court explained that FDA is an expert scientific agency that uses statistical analysis on a regular basis. And as a general matter, courts defer to the agency in the agency's views about what statistical methodologies are appropriate and necessary. I could also say just—
in the summary judgment context or just generally?
I'm sorry, Your Honor, I don't recall the answer to that question. I will say this, however, Your Honor. Simpson also went on to say that in that case, the statistical flaw was also basic, so basic to statistical analysis that deference wasn't even needed. And the same is true here. Pre-specification is absolutely basic to getting robust analyses of data that are obtained. There are some references in our brief that identify some of the underlying FDA guidances which discuss pre-specification. It is a standard that has been around for a methodology, I should say, that has been around for absolute decades and decades. And it is so fundamental that a failure to pre-specify is sufficiently fundamental that there is no need to have a hearing about whether pre-specification is appropriate or required here.
And on your alternative ground, you said there are two reasons why it's not required. One is the pre-specification problem. The second is the one identified by Judge Garcia, which is these studies don't even address the situation where there could be impaired next day functioning that a subjective person doesn't perceive, a person expressing their subjective feelings doesn't perceive.
That's right.
Is there any countervailing argument on that side, or countervailing evidence that's been submitted on that issue?
Not that I am aware of, not that the record indicates Vanda's experts attesting, stating that KSS is the gold standard and provides sufficient evidence, and awakeness is evidence of next day functioning. But that is just an assertion that—
But that still just goes to awakeness as opposed to impaired functioning where you don't perceive that.
That's right. There is no evidence in the record.
There's no evidence in the record that there's a dispute about whether their evidence can prove that you can have impaired next day functioning that's not related to your perceptions.
There is no— So I want to be careful here. I'm quite certain that Mr. Hughes will say there is such evidence.
Okay.
The evidence he will point to is Vanda's expert declarations stating that degree of awakeness is correlated with next day functioning. The FDA's determinations on that issue, however, was that there is no support for the expert's assertions that the two correlate.
The expert didn't rely on anything?
They cited data which the FDA looked at and said, this has nothing to do with what you have asserted.
Were they allowed
This does
to
not—
respond to that?
Yes, Your Honor, throughout the entire process. Absolutely, Your
And the
Honor.
experts ended up disagreeing, right? That's when you go to a hearing.
Respectfully,
They
Your Honor,
supported what
it's—
they said. You can shake your head all you want, counsel. I mean, be respectful of the process. I'm trying to understand what you're saying.
Yes, Your Honor.
And some of what you're saying sounds like gobbledygook, because you say, well, they said X and they relied on Y and they offered it. And so I'm sitting here thinking, well, did they offer something that was showing validity and reliability? And you want to summarily say no. No meaning what? What does that mean, no? that no one in their right mind could have looked at what they looked at and reached the conclusion they reached? Is that what you're saying?
That it was scientifically unsupported. Yes, that is what I'm saying.
Okay.
I guess my only follow-up to that is correlation the same as evidence of the actual thing that they need to prove? Is that?
Again, I need to be careful because these are statistical terms. I don't know that whether correlation or some other standard would be the most appropriate here. All I can say is there is no connecting fiber whatsoever. That is, whatever the standard is, they didn't undertake tests, for example, to show that two people who report that 7 on a KSS scale have successful driving ability given their report of 7, or whether they instead in a simulated driving endeavor would get into accidents on a regular basis, despite the fact that they indicated that they thought that they were very awake. There is no evidence of that sort. There is just the assertion that this is an adequate stand-in for functioning.
I understand. Thank you. Any other questions? Thank you very much.
Thank you, Your Honors.
Thank you, Your Honor. I'd just like to jump right to Judge Garcia's question, if I could, about the evidence that exists in the record showing daytime functioning. I'd start by pointing the court to Joint Appendix page 249. This is Dr. Ross' first expert report, and if I can read from it, the visual analog scale VAS has been used to measure sleep and wake function in clinical trials. It is common within the sleep research community to use VAS to, and this is quoting, measure aspects of sleep and daytime functioning and the effects of therapeutic interventions on them. He cites to that the Zisapels published article that was published in 2003, which we attach as Exhibit 180. That in turn cites to Nicholson, published in 1976, which we attach as Exhibit 129, which in turn cites to Parrott, published in 1978, which we attach as Exhibit 132.
I'm sorry, right. This is the key issue, right? That everything you said could be true. Alertness versus sleepiness correlates with your actual functioning. That is sort of obvious and indisputable. And the common example given is if you're sleepy, you will drive worse. It's like, you know, having drunk alcohol. The key question is if someone thinks they are alert, do they still function well? Which though is a different and more specific proposition. Am I making any sense?
Well, perhaps, Your Honor, but what I just read is Dr. Ross saying, if you are an expert in sleep medicine, you want to know daytime functioning, you look at the VAS, and he cites the 3 articles saying the VAS tells you daytime functioning.
Right. And do any of those have anything to do with the travel-related circadian rhythm difference? That means even though you feel great, I feel great, but when I start writing, my hand is shaking. I would still report on that study. I feel alert.
Well, Your Honor, I guess I'm a little challenged in answering the question. In KSS, we have 5 separate articles that connect the use of KSS to jet lag particular. But what Dr. Roth is testifying here is that VAS is if you're a sleep doctor and you want to know what is somebody's daytime functioning like, are they actually functioning well during that day? What you do is you administer a VAS to them and you figure out what their daytime functioning is. It's a methodological tool that you would use for insomnia, you'd use for jet lag, you use for a range of sleep conditions because it measures what somebody's functioning is.
Do you think the key is whether you have studies that say this is validated for the specific type of functional impairment that's associated with jet lag, with the circadian rhythm? And so so when we look for that, it's on JA 249.
Let me give you a lot more. So Joint Appendix
to 2022.
Yeah, so 249 is one place to start, but Dr. Ross' second affidavit, so this begins at page 2235. There is a heading that says VAS is an appropriate patient-reported measurement tool for next-day impairment associated with jet lag disorder. And then this continues for several pages.
But it can be appropriate, but it could be that it's not enough to check every part of the problem.
Oh, and that's a conclusion that FDA could potentially reach in the course of a hearing. We'll dispute that, but.
Well, but you don't dispute that you have no evidence about the issue of next day functioning that you subjectively feel fine, but in fact you are impaired.
No, we have
You-
loads
you
of this
agree
evidence.
That you have no evidence of that.
No, we have lots of evidence of this.
Okay,
We have.
Wait, let's bear down, because it seems that all of your studies are these subjective, asking people, how do you feel studies?
What the evidence says is if you're a sleep doctor and you want to know what somebody's daytime functioning is, this is
Okay,
what you do.
So I hear your argument to be that we shouldn't have to do that because all the experts say all we have to do is ask people what their subjective functioning is. But if we accept the idea that the definition of the disease and to treat it is you have to address these circadian rhythm things, and one of these things is you could subjectively say, I feel fine, but you could in fact be impaired. None of your studies address that. Your studies do address, they are relevant. If how you feel is going to be correlated with how you function, but they don't address the entire problem.
No, I reject that premise. I mean, our studies say, if you're a sleep doctor and you want to figure out criterion B under ICSD, this is what you do. We do what sleep doctors say you do to figure out criterion B. We don't think there's.
Those sleep doctors, were they talking about jet lag disorder or just general next day functioning after a bad night's sleep?
They're talking what you do. This is what Dr. Ross analysis. It starts on page 2,235. It goes on for several pages. He talks about the KAS starting at Joint Appendix 2,242, and it goes on for several pages. He says, and he cites many articles throughout it. If you're an expert in the field and your job is to figure out.
I understand that. So your argument is that if experts want to look at next day functioning, they use this test. But the issue is, in this particular context, which is jet lag disorder, it says there's a circadian rhythm aspect that is not captured in some of these other sleep disorder scenarios. And in order to treat jet lag disorder, you have to consider the circadian rhythm effects, and just merely relying on people's subjective statements of how they feel doesn't necessarily address that. So I'm not saying that your argument is irrelevant. I'm not saying that I'm just saying it doesn't capture the entire question about efficacy for this particular disorder that has an additional.
No, definitely not. Because let's start with the things that that Hetlios is currently approved for is non-24 and Smith-Magenis syndrome. Those are circadian rhythm disorders. FDA agrees that I think we're really the only product that is approved to treat circadian rhythm disorders. That's what makes this product different than all of the others. Most products just basically turn off your brain and knock you out, and that's why you have terrible next day functioning. What Hetlios does that's unique on the market is it entrains a person's circadian rhythm, so that way their brain, if there's not having an external light source, in the case of non-24 or people with blindness and Smith-Magenis syndrome, chromosomal disorder, in jet lag, it's jet traveled, induced phase shift. We know this product works for the circadian rhythm aspects of phase shift because we're the only product approved on the market to do it, and FDA has approved us for circadian rhythm disorders. The objection the FDA has is not, does it work for circadian rhythm disorder? They've approved us for circadian rhythm disorders. Their new objection is, well, what is the effect? How does somebody function next day? Because that's a criterion B. And so to answer that, we've gone to sleep specialists who say, okay, if you want to answer that, you use VAS and KSS to get that data. That's the data we have. That's what the expert report says. So I don't think there's a way to disentangle this for circadian rhythm, because again, we know our product works for circadian rhythm disorders. FDA can't dispute that.
The studies address that? Like the studies that you rely on here?
Well, I mean, there are a few things. It's the mechanism of action. So how this product works, we know that the mechanism of action is one that goes to the receptors in the brain that relate to circadian rhythm disorders. This is on the label that FDA has approved with the product. So, I mean, it's known that this is a drug that affects circadian rhythm disorders. So that's just sort of scientific background of how the mechanism of this product's action in fact works. But I know I'm getting technical with the science. What our request here is for the court to apply American cyanamide. We don't think the court needs to address this. We just, I think, are entitled to a hearing.
Can you just remind me what the best language in the second Roth declaration is that you were referring to?
Yes, Your Honor. It follows under the heading VAS as an appropriate patient-reported measurement tool for next-day impairment. And he gives quite a bit of evidence that follows from there.
Which page are you?
I'm on page 2,235. And again, I think what I gave you at page 249 is pretty dispositive, just to start there. I think that if you want one quote, I think what I gave you at 249 is clearest, where he says the sleep research community to use VAS to quote unquote measure aspects of sleep and daytime functioning and the effects of therapeutic interventions on them. And what he's saying is if you want to measure therapeutic intervention on daytime functioning, you use the VAS. And he's citing 3 peer-reviewed articles in order to make that argument. And then in the page range between 2,235 to 2,242, he goes through KSS and VAS in more detail.
Thank you.
Anything else?
No.
Okay, thank you.
Thank you.
We'll take the case under advisement.
Case number 24-7004. Mary Cecilia Williams, appellant, versus Julio E. Aviles, doing business as Universal Air Duct Services and Frederick Mutual Insurance Company. Ms. Williams for the appellant, Ms. Carson for the appellees.
Good morning, Ms. Williams.
Good morning, Your Honors. May it please the court. Mary Williams, appellant pro se. I am a lawyer, a wills and estates probates lawyer, but I'm also here as the homeowner of the home that was at 1257 Carrollsburg Place in the district. For the past 30 years, the District of Columbia courts have consistently upheld and strictly enforced the District of Columbia's licensing statutes and regulations, from Truitt versus Miller to Debarchi versus Self, Saul versus Roy, including this court. Until now, I stand before you today to say that the district court has erred in upholding the District of Columbia statute. The district court erred by not adhering to the protections that are afforded under the Consumer Protection Procedures Act. The district's licensing and statutes and regulations under Chapter 47-2853 requires all HVAC technicians, and we use the word HVAC versus heating and air conditioning, so that we would understand this, to be licensed in the District of Columbia. There has been no discussion or decision that Mr. Aviles was not a licensed contractor at the time. Mr. Aviles has stipulated to the point that he has never held a valid contractor's license ever in any state, and neither during the time in 2016 or 2017 when he installed the Train HVAC system in my home. But I'm going to address the legal issues that in the verdict from the district court judge Judge Maida, in the verdict, failed to provide specific findings of fact and conclusions of law in violation of the rules, violation of Rule 52A1, the Federal Rules of Procedure. The district court in his decision, the 13-page decision, did not address the actual question of law. The question before the court was whether or not Mr. Aviles's omission of the non-licensing status was material. At no time did Judge Maida address this in either the factual nor did he draw any conclusions of law. In fact, Judge Mehta completely overlooked this material fact and the questions of law.
So you just said it was an omission, but I thought he had asked you, are you alleging an omission? That is that it was never mentioned, or are you alleging a misrepresentation? He
And-
actually affirmatively lied to you. And I thought we were looking at a misrepresentation, not an omission.
No, Your Honor. I was misunderstanding during the closing of the trial. Judge Mehta did ask me if I was alleging affirmative statements made by Mr. Aviles. I understood him to ask me if I was just asserting affirmative actions. Under that, though, however, under the Consumer Protection and Procedures Act, I allege 4 subsections, and that is what was the question. And
But more, it was more of a factual question.
It was a
Like, what's your claim? Did he
My-
lie about this or did he just not mention it? And I thought your answer was he lied about it and then there's just a credibility determination.
under the Consumer Protection Procedures Act, there were 4 subsections. And what I alleged was that it did not matter whether it was affirmative. My evidence was affirmative. But he, in his defense, claimed omissions. But under the 4 subsections I charged were whether or not it was a material or an omission, a willful omission. Because under representation, false representation encompasses both affirmative misstatements and willful omissions. When the judge asked me whether I was just affirmative actions, which I had evidence of affirmative, but he would not let me finish to say that it doesn't matter under the Consumer Protection Procedures Act. He would have been found violating either one, Section A, B, E, and F.
So certainly the law has alternative theories of
Right.
liability, but at trial, you have to pick what your theory of the case is and commit to a factual narrative that is what you allege happened. And correct me if I'm wrong, my understanding was you committed to a narrative that there was an affirmative misrepresentation. There was testimony from both sides, and Judge made a credibility determination that the misrepresentation wasn't made, which we review for clear error.
The claims under my first complaint, and it was the same, each of those subsections, the affirmative was evidence. The judicial admissions, each where in the answers, interrogatories, and subsequent defenses, where Mr. Aviles stated that he told me he was an authorized, certified, trained dealer, and so forth. Those were affirmatives. In the defense, as I pointed out during the trial, is that under the DCPPA, that it doesn't matter, a willful omission was still material, and it was a violation of Section ERF. And that was what we were there for, to determine if his omissions were material. That was the question before us at that. That's what my understanding was at that time. And yes, during trial, I did present the affirmative discussions, but the verdict in the factual findings were totally erroneous. And this is why I'm asking you to reverse this, because the factual findings were totally erroneous. The judge, during the closing arguments, stated specifically that he was constrained to find material based on Saul versus Rowan, and is quoted. And yet in the verdict, a few days later, there was no mention of this actual recognition. There's nothing in the verdict that where he even considers the unlicensed status. And I just can't imagine we hear that even on summary judgment, which I applied for in that matter, based on the affirmative statements, which were considered judicial admissions. They were signed, they were witnessed, but he allowed no consideration of that and went straight to my credibility, when the question before us was whether or not his omissions were material. The most egregious part of it was in terms of the verdict. And I chose this part first was because throughout this very lengthy litigation, 7 years in on a basic personal injury claim, 117 documents filed. And we started with a defendant who pretended to be a licensed contractor and trained dealer because that's what I was looking for to install in my home. But then to find during deposition in 2021 that he's not, and that how did he obtain all of these things? It was a scheme to defraud, which kept it going and going and going. We're here now, and I'm just looking at summary judgment. How in the world did I get to here, the U.S. Court of Appeals? I did not expect that I would be appearing before you on this issue, for sure. I had hoped it would be in and out, but I'm here. And on behalf of consumers everywhere, I'd like to change my hat to being the homeowner. If you're out looking for HVAC and shopping and doing my due diligence, which is why in the summary judgment and the part where the judge excludes my expert, well, I have to ask the question, why should I have an expert when Mr. Aviles is not an expert installer? He just pretends to be one. He's not licensed by the District of Columbia, so who's giving him expertise? I would say on summary judgment, the standard of care has to be the reasonable homeowner, because he's no different given that he's not licensed.
Your time has expired,
Oh,
Ms.
sorry.
Williams.
Oh.
So we'll give you a minute for rebuttal.
Thank you.
Thank you. Ms. Carson. Good morning.
Morning. May it please the court, Sandra Carson for defendant appellee Julio Aviles. I want to start first with the issue of the verdict on the Consumer Protection Act case. I believe Judge Maida was very clear in his questioning of Ms. Williams. What do you want me to find? Do you want me to find it was an affirmative misrepresentation? Are you saying you do not rely on the fact that he failed to disclose? I believe there were 4 different times he questioned her on that, and each time she asserted that her cause of action, her claim that she wanted him to find on, was affirmative representations regarding his licensure and trained certification. That is a valid choice for her to make as a plaintiff as to how to pursue her claim. I believe the court's decision in that regard to rule on affirmative misrepresentations only was legally correct. Indeed, Ms. Williams continually referred to the failure to disclose as something the defense was raising. It was a defense. It was a defense. So I think that that ruling was correct, and I think that is why it wasn't addressed in the court's verdict later. Something else Ms. Williams mentioned was the idea that Judge Maida said he was constrained to find that the failure to disclose by Mr. Aviles was material. That conversation was not so much a statement of fact on his part, but it was a discussion and a colloquy between the court and myself as to the hypothetical. I believe Judge Maida prefaced it with something to the effect of, if this is part of the case, which I'm not sure that it is, let me ask you this question. And how is it not material? We had a discussion about that, but having determined that it wasn't part of the case based on the plaintiff's own representation to the court, I think there has been no finding that any failure to disclose was material. So in the event that this court were to find that it had to reverse on that issue, obviously findings need to be made by the trial court judge. But I do believe that the judge's actions in that regard were legally correct.
Why didn't he err on judicial admission?
He didn't err on judicial admissions because those were waived by the plaintiff, both by her failure to argue that they were judicial admissions at trial, her failure to object to the introduction of contrary evidence, Indeed, in her own case in chief, plaintiff put in evidence that contradicted the so-called
But
judicial admission.
Our case law doesn't admit of that. It may later, it doesn't now. He cited cases from other circuits, not from our circuit. In our circuit, judicial admission has to be accepted as a judicial admission, at least as the law is now.
Well, I would refer the court to the case US ex rel Yasudian versus Howard University. It's 153 F 3rd 731 from this circuit in 1998. There, the court was faced with a situation where a party admitted originally that an employee handbook equaled a contract, and later at trial put in evidence to the contrary. This court recognized that the plaintiff failed to note that the original admission, also failed to object when opposite evidence was introduced, and did cite and made note of the fact that, sometimes that is considered a waiver, and citing American Title versus Lace Law. Now, in that court, I acknowledge the court did not decide the issue of waiver.
Right.
It's, basically said, we don't decide that here, but I think that case certainly suggests that the possibility of a waiver.
In Canada, it says it's, the admission is generally binding on the parties in the court. And then he cites only authority from other circuits.
I believe that
So
plaintiff's own
American is
actions.
generally binding.
I think her actions in introducing contrary evidence would take away from any binding nature of those admissions. She didn't have, she brought that in herself. She didn't, it wasn't a matter of defense putting that into evidence first. She put Mr. Aviles on the
It's in his
stand.
pleadings.
It is in his answers, which are not verified. They were not signed by him. I know that doesn't change the fact that they are pleadings.
But our case law is that parties' admissions and its pleadings are generally binding on the parties in the court.
I do understand that. I do think, though, her actions in introducing contrary evidence on her own in her case in chief support the judge's reliance on the authority that he did and his actions in that regard.
And is it correct that Mr. Aviles was asked about that and he said he didn't know why that inaccurate representation?
Right.
He did. Yes, that is correct. And that was in a pleading prepared by counsel. And there is, Mr. Aviles is very heavy Hispanic accent. There may have been some communication issues during our first things. On that issue, that is our position. And I think that weighing the credibility of the parties, as the court did, I believe he did so properly. I do think the credibility of the parties is an issue. The mere lack of a license does not necessarily mean that he violated the sections of the Consumer Protection Act that plaintiff brought her action under. He was considering all of the plaintiff's testimony. He considered the defendant's testimony. He considered his original admissions versus the evidence that came in later. Obviously, his credibility determinations, the judge was there to see and hear the witnesses. Those are entitled to a great deal of deference. And I do believe that he did not make any errors in his assessment of the party's credibility at the trial of this case, and that the verdict should be upheld. On the other issues with regard to summary judgment, particularly plaintiff mentioned, why should she need an expert? She needs an expert because under DC law, when an action or a subject is so closely tied to a particular profession or involves safety or security, it is one that requires expert testimony. The question here is, did Mr. Aviles negligently install the furnace in such a way that it caused a subsequent gas leak? Plaintiff assumes that that gas leak was caused by him not tightening it. She chose not to put an expert in for that reason. 11 months later, after her disclosure deadline, 6 months after the rebuttal deadline, 3 months after the close of discovery, and 3 weeks before the summary judgment motion, she finally came up with an expert. Never really explained why it took so long other than to say COVID, but did not explain what efforts she made during COVID that were thwarted by that process. And to have an expert brought forth at that late date with an opinion that relates to nothing else that had ever been brought out in the case, nothing that anyone else had ever discussed, significantly prejudiced the defendant. And I believe the court appropriately exercised its discretion in striking that particular expert for the reasons cited in the opinion. With regard to the other issues on summary judgment, I believe that there is in the record no dispute of material fact on the issues of negligence, on the issues of breach of contract, and on the issues of common law misrepresentation. With particular issue to the breach of contract, I do note that plaintiff for the first time brings up in her appeal the idea of the contract is void or voidable.
What was the contract exactly?
The contract, if looking at the summary judgment record, is a single page piece of paper, and it is in the defendant's supplemental appendix. I apologize for that. It's at the supplemental appendix, and it is page SA5. It is a single page document, handwritten on a form filled out. And at her deposition, Ms. Williams testified that she received that document either at or before the time that work began, and that she signed it. She argues in her brief that, she called it an invoice at trial, and therefore that should defeat summary judgment, but that evidence wasn't in the summary judgment record. The summary judgment record indicates that this document, which shows exactly what he was going to install and how much he was charging for it, was something that she received before the work was done. In terms of the claim that...
But then the claim is about the leak, which isn't really addressed on this page. So is it like an implied warranty or?
She simply alleged that he negligently installed it. And her claim is that this contract required him to comply with all the codes and workmanlike fashion and
Yeah,
such
no, I'm
things.
asking you the breach of contract claim, not the negligent.
Right, the breach of contract
What is
claim.
the breach of contract?
It was that he improperly installed the gas line that led to the leak. She also claimed in the breach of
warranty or something, because it doesn't say anything in the.
there is I believe he writes on here somewhere 1 year, 3 years for labor warranty. That is written in the center section of page SA5, where he writes 3 years for labor warranty.
Okay.
And the breach of contract claim also encompasses an allegation that he didn't install other parts of the system right, that the contract doesn't even show that he installed, and that he denies he was ever asked to install. But in terms of her argument that this contract is void or voidable, she is trying to recover under the contract. She can't sort of have it both ways. She either has to recover under the contract or the contract has to be void. But I would argue that the issue isn't properly before this court, because she never did argue that before the district court at any point.
Thank you.
Thank you.
All right, thank you very much.
Thank you.
We'll give you 1 minute for rebuttal.
Thank you. Ms. Carson argues on my behalf always, as opposed to the experts. I did have 2 experts named within the disclosure period. They were 2 trained dealers who actually had investigated and looked over the HVAC system a week after the leak was discovered, not by anyone, but Washington gas technician Wayne Madden. And that is the causation, and that is the way it's going. The 2 trained experts were Jiffy's and Frosty's. Both Tim and Wayne actually saw and looked at the installation and declared it was horrible and shoddy. They were in place to serve as expert witnesses. The court, in deciding to exclude the experts, did not recognize that in the expert notice, they were listed, as well as Wayne Madden, who was the Washington gas technician who discovered the leak on the furnace 2 days after I left the hospital. So the allegations that Ms. Carson talks about my not being prepared and not having, the new expert, Brian Bramall, was only hired after the deposition when Mr. Aviles disclosed to all of us on April 23rd that he was not licensed and that he talked about the process he used. And therefore, a month after the deposition, I received the transcripts and going through the transcripts. And then I hired an engineer. The difference is I told him, I did not need a mechanical engineer because negligence per se was not necessary.
I think
And
this is in your briefing, so thank you.
so that's, the other part I'd like to
Your
just,
time's expired.
Okay.
Thank you so much.
thank you,
Please.
Your Honor.
Case is submitted. Thank you.
Thank you.
Case number 23-5180. David Rudometkin, appellant versus United States of America. Mr. Roberts, amicus curiae for the appellant, Mr. Dryer for the appellate.
Good morning, Mr. Roberts.
Good morning, and may it please the court. Chuck Roberts is amicus in support of appellant. I'm happy to get to the procedural reincorporation issue in the case, but the crux of this appeal is FOIA Exemption 5, as the court knows. In 2016, Congress decided to combat what it viewed as agency overuse of that exemption, and particularly the deliberative process privilege at issue here, by heightening the agency's burden to justify withholdings. This court's decisions in Reporters Committee, Machado, Amua, and Leopold explain that agencies now must concretely demonstrate foreseeable harm from the release of withholdings and specifically consider whether it is possible to segregate and release as harmless any portion of those exempt withholdings. The record here falls short on both fronts, much like the generic declaration in Reporters Committee with respect to foreseeable harm, and much like the incomplete declaration in Leopold with respect to segregability. The declarations here simply do not enable the court to conclude that the agency correctly understood and applied the FOIA Improvement Act's heightened burden. Vacatur and remand on either ground is therefore appropriate.
So even if you're correct that the declarations were too, I guess, generic, Reporters Committee says that more scanty declarations could be acceptable if the foreseeability of the harm is manifest. Why doesn't that apply here?
If that were true in Reporters Committee across the board, then the four categories that Reporters Committee vacated and remanded summary judgment on would not have been entitled to vacatur and remand. So the record here is not nearly as detailed either with respect to the foreseeable harm from release, which is the generic issue that Your Honor referenced, but also as to the sort of content, nature, context, all these other aspects of the documents here, particularly the ones that are not addressed in detail in the declarations, which we lay out in our brief.
I mean, we're talking about sort of a sensitive personnel decision and the selection of a judicial officer. And I guess one can imagine that you might be chilled from saying negative things about someone who's about to become a judge if you know that your comments might become known to that person at some point in time. It just seems to me that this is not sort of some of the other types of agency decisions that are made, like policy decisions or things of that nature. It just seems to me this is a little bit more sensitive. And so I'm wondering why that manifest harm standard from Reporters Committee might not apply in this context.
Yeah, the first line response to that, I guess, is as Your Honor mentioned, you're imagining those harms. If those harms are so straightforward or so simple, then the agency here very well could have put them into the record. But what we have in the record here, including the Vanda Index describing many of these documents, aren't necessarily the sensitive sort of materials that Your Honor posited. What we have are lists of criteria, for example, that are under consideration, maybe factual information or biographical information. Those aren't necessarily the same sort of sensitive.
Assume for the moment we're just talking about the recommendations, and even easier, the recommendations from the JAG to the Secretary. What, in your view, I agree there's not a ton here, but what specifically more needed to be? Can you give me a sentence or two that would have solved the problem that is missing?
Yeah, I would say sort of the easiest way to answer that question is actually to put side by side the declaration here with the declarations in Amua and Machado. And you'll see that those go on for pages about much less information than here, even much less than the disparate recommendations here, because we have recommendations by JAG officers, we have recommendations by OGC attorneys within OGC, and it's not exactly clear what role those play.
And a lot of those pages are sort of explaining the context. And when it comes down to it, in those declarations, they sort of seem to make the same arguably generic statement here about what the harm is. They just say, these are recommendations, and if you disclose them, the quality of the recommendations will be harmed, and so the decision will be harmed. And there's less of the context around here, but that basic statement is in these declarations, isn't it?
It is and it isn't. So there is the would, there is the use of would cause foreseeable harm within especially the first declaration. But then when the agency gets a second chance, it actually starts hypothesizing what harm could follow from release of these documents. And this court's decision in Machado, as explained and sort of reinforced in later decisions, makes clear that could doesn't cut it. So that's another thing that I would say the court needs to say that agency needs to change in its declarations here is not imagining or hypothesizing what foreseeable harm might flow from release of these documents, but specifically within the context of these decisions, what harms would flow. And the conditional.
So for example, we ought to say, you need to put in writing that JAGs would fear being explicit because they're going to be, practicing before this judge. So even though we might say, it seems to me, frankly, the debate in this case is about, is that so self-evident they don't need to say it? Or is there some reason they actually have to add that sentence to the declaration? So what?
Well, there's much more in this case than just the bottom line recommendation by the JAG officers. There's many other categories of documents, but even as to just the bottom line recommendation, what's withheld here are substantially all of pages of recommendations. And so it's not just the sentence, I recommend or don't recommend this person. It's the entire document that contains that recommendation. And that's where the segregability analysis comes in and says, we don't have a basis here to conclude that the agency went through and segregated potentially harmless exempt information.
Before we get to segregability, it seems to me that the government defines the categories as the substance of the actual nominations and accompanying advice and recommendations, or information within emails and internal memorandum provided by the general counsel and other attorneys advising the secretary regarding designation. Those categories, it seems, could fall into sort of a manifest foreseeable harm standard in this particular context. But to me, it's a separate issue whether the actual documents fall within these categories. So I think that there's a sort of two-step process we need to go through in determining this. And I'm not hearing yet anything, a strong argument from you about why, generally speaking, this context of personnel decisions, judicial selection, et cetera, might show manifest harm to the interests of this exemption. There is a separate question about where these particular documents actually fall within that. But as on a more general level, these categories and this interest, there does seem to be a connection and a manifest foreseeable harm potentially.
Well, I would just say that first of all, the categories are inconsistent across the government declarations. We laid that out in our brief, and the district court just understood the entire record of 64 withholdings here to be the actual recommendations, which simply can't be the case because there's more withheld than just the bottom line recommendations. As to the specific context of recommendations or non-recommendations for a judicial selection, one could imagine much information going into those recommendations or not recommendations that might be sensitive, that might not be sensitive. That burden is on the agency to put that forward, to put that into a declaration. It's not this court's burden to imagine what that context or that purpose might be. I think the comparison maybe to Reporters Committee and the particularly sensitive context of two of the categories of documents there might help the court in thinking through the manifest question that Your Honor is getting at. And those two were sort of ongoing covert FBI operations that were being discussed in the documents there. And that in combination with the agency declarations and the assertions of foreseeable harm in those declarations allowed the court to say, in the context of ongoing covert FBI operations, particular national security sensitivities, we understand that the foreseeable harm here is clear on this record than I think what we have here. I'm happy to address segregability if.
I just had one question on that. So it seems there's certainly a technical reading of Leopold, sort of, they at least have to claim that they conducted a segregability analysis with foreseeable harm in mind. I take it that's your basic position. And I wonder if in this particular case, right, what they've done is they did do a segregability analysis and released essentially everything that's not an opinion, right? And then they have a foreseeable harm justification for the opinions. So it seems like if we remanded for them to do a segregability analysis with foreseeable harm in mind, they would just sort of say, we already did that, or our justification already explains that everything we're withholding is already the type of thing that causes a foreseeable harm.
I think that's possible, but it's equally, if not more possible, that another result might attain on remand. So Machado involved sort of a situation where the court sort of looked at one type of information, one data field in these blitz forms, and said these few sentences, the agency has said that it has conducted a segregability analysis and a foreseeable harm analysis. Together, we recognize that that means that they probably don't need to add that sentence about segregability with respect to harmlessness. What we have here is substantially all of 64 pages withheld. And there may be a lot of opinions in there. There may be just an opinion and then a lot of facts and analysis going into that opinion. We don't know because they're withheld. And so it's much harder to sort of gap fill for the agency here than it was in Machado. And that's sort of where Leopold comes in. Leopold was all or substantially all of a document withheld. The court simply wasn't able to tell that the agency had gone in and done the segregability analysis with respect to the exempt information. And you should take the agency's declarations at their word here that they only did the segregability analysis as to exempt versus non-exempt information, not within exempt information with respect to harmlessness.
You got to remember, though, one of the principal justifications in exemption 5 is you're trying to protect open communications and full and candid advice. And so it's hard to pick sentence here and there, because when someone is giving advice, you're thinking about how to frame certain sentences all in context, and to give any of that away is to chill it in the future. Well, if you're going to give all of part of what I'm saying in my advice memo this time, I'll never give it to you again. I'm not going to explain it. That's exactly what we're trying to protect against.
I agree that that's the rationale for exemption 5, but sort of the process point in the FOIA Improvement Act is for the agency to show its work in doing that analysis. It's for the agency to.
Well, how do you show it other than showing it, and you don't want to show it?
Well, with respect to segregability as to harmlessness, it's for the agency to say in the record that we conducted this segregability analysis as to harmlessness. And that's what they said in the AMUA declaration. That's what they said in what they didn't say in the Leopold declaration. And sort of that's the dividing line, is the agency needs to show its work.
Thank you. We'll give you a minute for rebuttal.
Good morning. May it please the court. Douglas Dreyer on behalf of the United States. I want to pick up on the manifest point. And I'd go back to the Supreme Court's decision in Klamath Water, which pointed out that the deliberative process privilege rests on the obvious realization that officials will not communicate candidly among themselves if each remark is a potential item of discovery and front page news. We are here talking about a FOIA request concerning the nomination and selection of an individual to be a chief judge. So the agency's declarations that we're dealing with here, it's primarily 4 paragraphs. And I recognize, as your honors pointed out, that there's not a whole lot there. And I fully recognize that's the case. However, we submit that between paragraphs 8 and 9 of the first declaration and paragraphs 10 and 11 of the second, the government has shown that it foresees that further disclosure would cause harm. And specifically, in paragraph 11 of the second declaration on A126, the government stated, quote, "The material redacted from the responsible documents was withheld because it is reasonably foreseeable that disclosure of this information would harm the full and free discussion of the nomination within the agency." So that's talking about disclosure at the level of information. It's context specific, talking about the full and free discussion of the nomination within the agency, and it is using would language, not could language.
Counsel, I appreciate that argument. It certainly has some force, but if you step back and especially if you start from the premise of reading, that language from Klamath, then all you ever need to say in an Exemption 5 case is this is pre-decisional, it's deliberative, disclosing it would cause harm. And maybe, you have to say this information instead of any information of this type. But, Congress must have thought it was doing something when it enacted the Improvement Act, and it evidently was specifically concerned about Exemption 5 withholdings. Wouldn't we basically be nullifying the statute?
So I don't think that's quite the case. So in Reporters Committee has already set out that the government can't do just that. The government does need to say more than just repeat a legal conclusion. But the government can't go that far beyond what is the interest at issue, because then we're not talking about a harm that the interest is designed to protect. And so then we get into a separate issue with making sure the harm is correlated to the exemption. So we have to use the language. And here I have to go back to, there is a presumption of regularity with government declarations. And there's a presumption that the government is faithfully fulfilling its task. And I think that while it would be insufficient to just repeat a formulaic legal conclusion, I don't think that's what we've done here. And I'd point out, paragraph 8 of the...
This made it more explicit that we are talking about a personnel decision. We're choosing a chief judge. The people here are going to have to work with this person. There's just none of that kind of details spelled out. And then we're left to see, well, is that manifestly obvious? And you never made a manifest argument in your brief.
We did include the obvious realization language from Klamath. I do think we've...
Well, you described what the case has said, but you never actually affirmatively argued that it was manifest from this context.
We do in our brief focus a lot on what the FOIA request is. And so I agree with Your Honor that I don't think we use the particular phrasing. I think the substance is there.
We researched this. I think you can rely on whether it's manifest, even if you don't raise it. I don't think that that's something that you can forfeit, because if it's manifest, it's manifest. But it just seems to me that the declarations are pretty perfunctory, and then the briefing doesn't really make the strongest arguments. You're making our job harder. That's all I'm saying.
I apologize, Your Honor. And I'd go back to, so in paragraph 8 of the first declaration, the agency does say that release of this information, and that's referring to the substance of the actual nominations and accompanying advice and recommendations. So release of this information would cause harm to the Secretary's decision-making process, as it would hamper the unfettered and candid advice of those making recommendations to the Secretary if that advice is no longer kept confidential. And there's similar attestation in the following paragraph regarding the communications from the General Counsel's office. So in both cases, we are giving more of a hook, more context concerning the FOIA request. But at the end of the day, we are talking about a request for the materials pertaining to the nomination and selection of an individual to be chief judge. And if the government didn't say enough in its declarations, the court would remand, and we would likely end up back in the same position with a declaration that would provide the additional materials you would say that are required. But we submit that that two-step process isn't necessary here.
You're saying in any case, the context matters. And once you state the context, that's going to speak volumes.
Yes, Your Honor.
Because you're setting it up. It's going to be more obvious, clearly obvious in certain kinds of cases, once you said this involves a request with respect to. It is a personnel matter. That's obvious because you put it in context. That's your argument, right?
Correct, Your Honor.
So adding lots of words over and above that, it's not hurtful, I guess, but it's not really helpful.
We could be like the first case you heard this morning and have an appendix that has more than 2,000 pages, but I don't think we need that here. I think that the declarations we have are fulfilling the government's burden of attesting that there is harm from further disclosure. And it's using would language.
So I think this arguably it makes a lot of sense for recommendations from the JAG. That's not the only category of documents. And for example, it looks like there's a lot of internal discussion in the GC's office. Why isn't there some value in requiring the government to say these emails, were material to the, formulating the advice for the secretary? That is the kind of thing that was done in pages, in not 1,000 pages, but maybe two, more than one sentence in the Machado case and the Amua case. And, one view in these FOIA cases is that the government wins once it puts down an explanation. So we ought to at least require them to put down an explanation.
And I understand that, Your Honor. So for that, I'd refer to paragraph 9 of the first declaration, which states that, and it's talking about those attorney-client communications, the recommendations, the emails within the Office of the General Counsel. And it says public disclosure of the attorney-client communications would seriously disrupt open communication between the Secretary and his attorneys, as well as deprive government decision makers of the full and candid advice of their counsel. Indeed, disclosure of this type of deliberative memorandum would hamper the day-to-day workings of the department, as senior attorneys would no longer feel free to convey their recommendations in formal written correspondence. So that paragraph
There's
is
two sentences. And I think this is, there are strong arguments on both sides, but those two sentences are, I don't know any way to describe them other than generic, right? You've just inserted these attorneys for employees and this information for deliberative information. Maybe that's all that's required, but it looks a lot like the explanation that was rejected in Reporters Committee, doesn't it?
Well, keep in mind, for Reporters Committee, 2 of the categories were found to be sufficient, and using the same generic language that was insufficient for the other 4
They
categories.
relied on that manifest.
Correct, Your Honor.
Yeah.
Eh,
So it seems though that even if you're correct that based on the context, it's manifest that there's harm, the specific documents don't necessarily fall within the exception that you're trying to advocate for. Like document 5, internal OGC notes regarding action memo to Secretary of Defense regarding designation. I mean, it's just unclear that actually would contain sensitive information because we don't know if it's about an actual recommendation or the process of designation, or we don't know what that is. Same with documents 6 and 15, advice regarding designation.
so-
Document 21, it just seems that even if you're correct about there is foreseeable harm based on this manifest harm from the record, is actually the specific documents, it's not clear to me that they fall within the categories that you're trying to protect, which is recommendations, sensitive things about this personnel issue. Wouldn't we have to remand at least for that purpose?
So Your Honor, I'd refer then to paragraph 9 of the second Harrington Declaration, which does provide additional information. So for instance, paragraph 9E, which is pages 124 on to 125, talks about document 5, which Your Honor began with. And it says document 5 is an internal Department of Defense Office of General Counsel routing cover sheet for document 6, which contains analysis and recommendations from other. It's page 124 on to 125. It's paragraph 9E as an echo of the second Harrington Declaration. So it says it's an internal DoD OGC routing cover sheet for document 6, which contains analysis and recommendations from other general counsel attorneys.
But just a cover sheet?
And then the following.
Well, the attached document contains the analysis. Why is the cover sheet
So
sensitive?
it's a routing sheet, and so in the following paragraph 9F, it gives, because I think I would use routing sheet maybe a little differently, but I'm not in the services. A routing sheet is a document used to memorialize the staff review of a document. This document contains concurrence or non-concurrence information, as well as recommendations from the services and various members of the Secretary's staff. So I'd submit that paragraph 9 does provide additional information about the documents beyond what's in the Vanda Index. And I note The district judge's first opinion did fault the government's Vaughn Index for being a little too conclusory. And so that's why in that second Harrington declaration, I mean, Your Honor also pointed out document 21, that's paragraph 9G is in Gulf. And it says document 21 is an information memo included in the recommendation from the General Counsel to the Secretary, which provided analysis of the requirements and considerations for appointing a new chief judge. The analysis of the requirements is unique to each candidate. So the Vaughn Index isn't the sole source of description of these documents. There is more, and it is in paragraph 9, which has a series of different subparagraphs.
Why are 23 and 16 and 24? Why are they excludable?
I'm sorry, Your Honor, I didn't hear.
Selection criteria.
Okay, so that's paragraph 9C is in Charlie.
Yes.
What document 23? Why is that excluded?
So this is request for input from the General Counsel to the Service Branch JAG seeking recommendation. The document contains selection.
Starting with respect to the selection criteria. And 16 is a draft of 23. And then 24 as well, includes the departing chief judge's recommendation on the selection criteria. Why is all that excludable?
Well, so this is all pre-decisional. It's all deliberative. The final decisions with the secretary. And this material goes into the ultimate decision as to who to select to be the chief judge.
Yeah, I understand, but why is that somehow fit in exemption? That is, it's like a job post, the selection criteria.
I understand, Your Honor. So
A124, it says these documents include the outgoing chief trial judge's recommendation
Right.
and biographical information for all candidates. I guess there's a recommendation, but it's probably might be segregable.
So on the question of whether this is under FOIA exemption 5's deliberative process privilege at all, what I'd have to go back to is that issue has been fully forfeited on appeal. So the material withheld, it's uncontested on appeal that this is pre-decisional and deliberative. As far as the merits of that, document 16 was in the second category of emails and internal DOD memorandum provided by the General Counsel and other OGC attorneys advising the Secretary regarding the designation of Colonel
I'm
Watkins.
saying the selection criteria question, to the extent that that's what we're talking about, it's uncontested and therefore you don't have to really answer. Is that your answer?
So
You have to answer foreseeable harm.
correct. We have to be able to identify the harm that the government foresees from further disclosure of this material.
Yeah.
On the
23.
So for document 23, this was listed in the first category, so substance of the actual nominations and accompanying advice and recommendations. And document 23, the request for input from General Counsel to the Servants Branch, JAG seeking recommendations. So this is all material that is going into the ultimate decision as to the selection of the chief judge. And I fully recognize, Your Honor, that there could be more here. There can always be more in a FOIA case. But what we have on those documents are in those two paragraphs of the respective Harrington declarations.
Okay.
Thank you.
I respectfully ask the court to affirm. Thank you.
Just a few quick points on rebuttal. I'm happy to answer any questions, but the fundamental question before the court is whether the agency correctly understood and applied the governing legal principle, the test from the FOIA Improvement Act, and this court's cases interpreting the FOIA Improvement Act to require concreteness, to avoid perfunctory, imaginative, speculative language. And it's just unclear on this record whether the agency understood and applied that governing test. And in fact, it seems like the agency is continuing was continuing at this stage, business as usual, sort of the check the box, foreseeable harm. I can sort of put in the generic rationale, and that'll be good enough to get past summary judgment in a FOIA case. Congress, as Judge Garcia mentioned, must have been trying to do something with the FOIA Improvement Act. And if this court were to affirm across the board, or even to affirm just as to the recommendations that are addressed in the declarations here, I think the court should be concerned that it would be causing confusion amongst the precedents that we cite, the key cases here, Reporters Committee, Machado, Amua, sort of what falls on which side of the line. When does the district court to get involved in gap filling or to imagining or to saying this is manifest or not manifest, whether or not the government makes that argument in front of the court. It's just much simpler here to say this looks a lot like the relics of the pre-FOIA Improvement Act declarations that Congress wanted to change. Therefore, go back and try again. If it's an easy exercise, as my friend suggests, then it's an easy exercise, but Congress was targeted at the process. The agency going through the exercise and showing the work of its exercise, reviewing these documents and making sure that FOIA's strong presumption of disclosure is upheld with respect to the deliberative process privilege in particular. If there are any questions about the procedural reincorporation issue, I'm happy to address that. Otherwise, I would respectfully ask vacatur and remand on both issues.
Thank you. Mr. Roberts, you accepted the court's appointment as amicus, and we're grateful for your assistance.
Thank you.
Case is submitted.
This honorable court now stands adjourned until Thursday, January 16th at 9:30 a.m.